Is the legal battle over for AR-15s and other modern sporting rifles, or are the anti-gunners going to win on banning those evil military-style so-called assault rifles? What if I told you that two of the nation's most important anti-gun judges are now on record saying that they are in common use, which seemingly means that they should be untouchable according to the Constitution? Guys, we're going to take a look at this, what it means, what you need to know, so let's get into it. So the common use test emerged as a pivotal standard in the District of Columbia versus Heller. That's the 2008 Supreme Court case where the court affirmed that the Second Amendment protects an individual right to bear arms. That's back when the anti-gunners were saying there's no individual right to bear arms. It's some sort of community right. That's code for cops and National Guard. Justice Scalia, he's one of the heroes of this story, delivering the majority opinion, rooted the right in historical context. He wrote, quote, "We think that Miller's ordinary military equipment language must be read in tandem with what comes after. Ordinarily, when called for militia service, able-bodied men were expected to appear bearing arms supplied by themselves and of the kind in common use at the time," end quote. To learn more about what this was like, check out our video series that I've gotten tons of positive feedback on, both in person, randomly when I go places, when bump into people. We did a 3-part video series about April 19th, 1775, the battles of Lexington and Concord, what it was like for those brave men who answered the militia service call and the arms that they brought on those days. This language, talking about the fact that protected arms are those that would be bearable by the militia if they were answering the call to bear arms on any particular time as their community needed it. This language established that the Second Amendment shields firearms that are in common use by law-abiding citizens for lawful purposes such as self-defense. Not only firearms used for self-defense, as the anti-gunners are trying to twist it, it's lawful purposes such as self-defense. Heller struck down DC's handgun ban, which cemented that weapons in widespread civilian ownership, like handguns in that case, are constitutionally protected. Now, the court doubled down on this principle later on in 2016, again in Kavanagh versus Massachusetts. This was the stun gun case. This case addressed whether stun guns fell under the Second Amendment, and a per curiam opinion, that means everyone, clarified and roared, I would add, quote, "The court has held that the Second Amendment extends prima facie," that means on its surface, "to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding, whether the founding in 1775 for the first battles of the American Revolution, April 19th, Lexington and Concord, whether we're talking Declaration of Independence, whether we're talking the passage and adoption of the Second Amendment, 1791, take your pick." The court rebuked the state of Massachusetts for arguing that stun guns were not protected because, hey, they didn't exist in 1791, and the court called this logic, in a very tongue-in-cheek way, inconsistent with Heller. This ruling expanded the common use doctrine test to modern arms, if it wasn't there already, which of course it was, which emphasized current ownership rates over historical prevalence. Now, in New York State Rifle and Pistol Association, you're going to see where this is all going. I'm setting up the pieces on the chessboard. Stay with me. Then in the Brune decision, that's the 2022 U.S. Supreme Court decision. And in my view, we go Heller and Brune. There's other big, of course, Second Amendment Supreme Court decisions, but these are like the golden two. These are the golden two. People are going to be talking about these 100 plus years out. The Brune decision in June of 2022, the court refined its Second Amendment framework, some would say. While focusing on the public carry aspect, Justice Thomas articulated a broader standard. Quote, "When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation." Brune did not directly invoke common use in the same way that Heller did, but rather it built it into this historical tradition test. It built it into the framework. It contextualized it. Why? because courts were basically using means end testing, and I won't bore you on it, but courts were basically anti-gun courts were really just destroying everything by going to reasonable tests, means end tests, and all this other kind of stuff. And this reinforced that widely owned firearms align with America's legacy of armed self-defense. Which brings us now to the AR-15 and the AK-47 and all these other evil semi-automatic rifles as lightning rods in the gun debate. The AR-15, dubbed America's rifle, boasts millions, in fact, tens of millions of owners, making it the nation's most popular rifle. The AK-47, while of course less ubiquitous stateside, shares a similar profile of widespread civilian use. And of course, there's a lot of others that fit in that bill of semi-automatic centerfire rifles. Yet, anti-gun advocates often claim that these rifles are not in common use, arguing that they're unprotected under Heller. The Supreme Court's own justices, including 2 unexpected allies, have helped to undermine this attack. These are Justices Sotomayor and Justice Kagan. Justices Sotomayor and Kagan are typically not aligned as being pro-gun justices. They fall on the firmly anti-gun side of the court. However, they have made statements that fortify the common use argument for AR-15s and AK-47s. In the 2024 case, Garland versus Cargill, this is the bump stock case that we've covered. Justice Sotomayor dissented. In other words, she didn't want bump stocks to be legal and all that other kind of stuff. But in her dissent, describing the Las Vegas shooting that of course precipitated all this back in 2017, she wrote the following, quote, "Within a matter of minutes, several hundred rounds of ammunition. The shooter killed 58 people and wounded over 500. He did so by affixing bump stocks to commonly available semi-automatic rifles." End quote. Sotomayor's use of commonly available and even common mirrors Heller's exact terminology. And the rifles she's talking about are AR-15s. This is a Supreme Court justice in an official opinion that's about the Second Amendment, acknowledging that AR-15 style rifles are widely accessible, owned, and in common use. For those of us defending these firearms, this is gold, especially from a justice who is, let's just say, often skeptical of gun rights. Justice Kagan, Justice Sotomayor's close ally and colleague on the court, echoed this in the recent Smith & Wesson Brands Incorporated versus ESTADOS UNIDOS MEXICANOS recent case that just came out in 2025, which addressed Mexico's lawsuit against gun manufacturers. Justice Kagan wrote, quote, "Mexico here focuses on the manufacturer's production of military-style assault weapons, among which include AR-15 rifles, AK-47 rifles, and .50 caliber sniper rifles." Those are all her words. Cannot emphasize that enough. But those products are both widely legal and bought by many ordinary consumers. Then she wrote in parentheses, "The AR-15 is the most popular rifle in the country." End quote. Justice Kagan's blunt admission that AR-15s are the most popular rifle in the country, i.e. the United States, and purchased by many ordinary consumers is frankly just a legal bombshell. It directly supports the Heller standard, proving that these rifles are in common use today. So these quotes are seismic, and that's not some sort of YouTube hyperbole. That is a legal analysis from a real attorney, because they come from the court's liberal anti-gun wing, justices that are not only presumed to be in favor of gun control, they are in favor of gun control. When even Justices Sotomayor and Kagan concede that AR-15s and AK-47s, they are common, it dismantles the anti-gun argument that these rifles are somehow fringe and therefore unprotected. Remember, a weapon has to be both dangerous and unusual, according to some arguments about what weapons you're allowed to ban. If they're in common use, how could they be unusual? Their words, etched in Supreme Court records now, provide pro-Second Amendment advocates with powerful ammunition, pardon the dad joke, to challenge bans. If justices hostile to expansive gun rights cannot even deny their prevalence and their commonality, lower courts and lawmakers, to say the least, face a bit of an uphill battle arguing otherwise. Snope v. Brown. This was the Supreme Court's chance to take this AR-15 case up, AK-47 case, all that other kind of stuff. Yes, we did a video covering this. I'll cover it again very briefly here. Despite the clarity that we just covered, the Supreme Court recently declined to hear Snope v. Brown, which was a challenge to a state-based AR-15 ban. This punt was, to say the least, disappointing. Disappointing to me, disappointing to you, disappointing to many. However, thankfully, Justice Kavanaugh offered some hope and some insight in a statement respecting the denial of the certiorari. Certiorari is what the Supreme Court has to grant in order to accept a case to be heard. For every case that's heard, there's almost 100 cases that are denied. They just lack bandwidth. Justice Kavanaugh wrote, quote, "I understand the importance of this issue, and I share the view that the court should grant certiorari in an appropriate case to address the constitutionality of laws banning or restricting access to semi-automatic rifles." End quote. He then went on to acknowledge the fact that he thinks within the next few years, we're likely to see a definitive ruling on whether these rifles, which are undeniably now in common use, are constitutionally untouchable. We've got the two anti-gun judges. We got two of the anti-gun judges that have acknowledged in writing on Second Amendment cases on the Supreme Court docket, AR-15s are in common use. Does that mean the war is over? Of course not. Even with Heller, even with Catano, even with Bruin and these admissions by Justices Sotomayor and Kagan, anti-gun judges and legislators are not going to surrender. They'll argue these rifles are too dangerous, they're too military, they go beyond civilian need, they are dangerous and unusual, they are used to affray, all this other kind of stuff to sidestep those two magic words, common use, with emotional appeals, or I'm sure we're going to see some continued novel legal theories. The fight is far from over, but it is evolving. The Second Amendment's defenders must remain vigilant, leveraging the court's own words to protect our rights. If you want to see a video where I dissect a lot of these anti-gun arguments, which I've done kind of piecemeal, but I've yet to do an entire video just focused on the anti-gun arguments and why they fail for AR-15s, let me know down in the comment section down below. Be happy to do that. Drop that comment down. As always, be sure to hit that like button and reward the brave among you with a Dwight D. Eisenhower quote to close out this video. The General and President, Dwight D. Eisenhower, once said, quote, "Freedom has its life in the hearts, the actions, the spirit of men, and so it must be daily earned and refreshed. Else, like a flower cut from its life-giving roots, it will wither and die." Always great words from the General. I look forward to seeing you again in the next one. I look forward to seeing the comments. Be sure to like, and I'll see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.